At issue in this case is, what is the proper remedy under the Pretrial Fairness Act when a reviewing court finds that there was insufficient evidence presented at a detention hearing on one of the statutory elements of detention?
And so we're just asking for this to be sent back for another hearing. I would note that I don't know that it will have much effect in this case as a practical matter. It's my understanding that trial is set for late April. So the case could become moot. It's not moot yet. I don't know that the trial will go ahead, but I do think it's important as a, or I should say that the sort of overarching issue of, in circumstances like this, is automatic release appropriate? I think it would be important for the court to say that no. I mean, we're not going to just say, we're not going to have like sort of a gotcha system where the hearing didn't go as it should have gone, and so that was the state's only opportunity. And we're just going to release a defendant without regard to whether or not the evidence shows a danger or a flight risk.
We had a full hearing on this question. It's not a question of automatic release. It's just enforcing the presumption of release that is written into the Pretrial Fairness Act that the state did not get its burden to overcome.
This is the court's second pretrial detention case of the morning. The biggest difference between this case and the previous case is that everybody here is in absolute agreement that the substantive nature of the circuit court's order of detention was correct as a matter of law. It was supported by sufficient evidence. The court correctly determined that this defendant could not be released without endangering the community. The question presented here is whether an alleged timing error in the holding of a continued detention hearing deprived the court of its authority to enter that order.
The legislature, in crafting subsection C2, could have excluded weekends in general, and it didn't. It has done so in other statutes by choosing to exclude that provision in subsection C2. That should be given effect.
They're even assuming that this was 2 hours late. He's not entitled to invalidate the detention order, and the court's authority to detain him was preserved.